Hello friends, welcome to Insights I Can Initiative. Today's topic is about the Gyanvapi Masjid case. Okay, so before we discuss further, first we will finish the syllabus mapping, then we will see the components of the video, what we are going to discuss. Gyanvapi Masjid case. In this background photo, you can see the Gyanvapi Masjid, and one side of the masjid is having the temple-like architecture. Okay, so syllabus mapping. It is related to Gender Studies, Paper 2, Government Policies and Interventions and Judiciary. Because here in this video, we are going to discuss about one Government Act, okay, that is Places of Worship Act. That is the reason it comes under this topic of government policies. Then we'll see video components. In this video, we are mainly going to focus on the Gyanvapi Masjid case and its relation to the Places of Worship Act 1991. Okay. We will see the background of the Gyanvapi Masjid dispute and the Place of Worship Act 1991, in which context it was brought, and what were the exemptions given from this act, and why this act was introduced in India, what was the necessity behind this act, and what are the challenges about this act. That means why. So there are certain challenges in the implementation of this act that we will see. And finally, we discuss about the Archaeological Survey of India. So these are the areas we are going to focus. So before we start further, first I'll ask you one question, students. Which article of the Indian Constitution says that it is the responsibility of government to protect the places of national importance and heritage structure? Which article talks about the protection of places of national importance and heritage structure? Okay, please put your answer in the comments. Now, so let's see, we are going to discuss about the Gyanvapi Masjid case. First, let me briefly explain about the issue, then we will come back to this. Okay. Gyanvapi Masjid Row. Gyanvapi Masjid Row or Masjid disputes. Masjid disputes. The simple facts. Let us go through the critical analysis. So first, what is the claim of some of the Hindus? Some of the Hindus, they are claiming that, okay, obviously one side of the mosque is having the temple architecture. During those days, it was very common that Muslim rulers, they attacked Indian temples, and even, okay, they demolished these temples, and they use the same architecture in the mosque also. If very popular example was Quwwatul Islam, Quwwatul Islam, Quwwatul Islam. There you will see the temple pillars. Whatever the kind of pillars you can find in temples, those pillars will be used. Were used in the Quwwatul Islam. You know, the students, Quwwatul Islam was constructed by the Qutub Minar. Like that, many Islamic constructions, they featured the temple architecture. Okay, Hindus were claiming that this place belongs to the Hindus. This place belongs to the Hindu worship area, Hindu worship. So Hindus are believing that in this place Hindus should be worshipped. Regarding that, they approached the Varanasi district court. Varanasi district court, they approached, okay, Varanasi district court. Later they approached the Allahabad High Court. Allahabad High Court. Then Supreme Court also. Allahabad High Court, they approached, and finally Supreme Court. Okay, and from Muslim sides, okay, from Muslims sides, they are quoting about the act that is known as Places of Worship Act. They are quoting Places of Worship Act 1991. What is this Places of Worship Act 1991? It is saying that, okay, cutoff date is 15th August 1947. It is saying that cutoff date is 15th August 1947. What is this cutoff date? By 15th August 1947, if a place is temple, that will be remain as a temple. If a place is church, that will be remain as a church. Again, you cannot go to court. That means by the time of Indian independence, if a particular place, for example, X is an institution, it is a temple, okay, temple by the time of 15th August 1947. Now you cannot go to the court and you cannot claim that it was at mosque or it was a church, you cannot claim. The fixed point was 15th August 1947. Okay, but by this time already Babri Masjid dispute was going on. That is the reason from this act, exception given to Babri Masjid, exception given to Babri Masjid, as well as exception given to archaeological structure, archaeological structure, archaeological structures, they were exempted. They were exempted. Now, why we are discussing about this in today's video? We are discussing that Varanasi district court initially it called for the video survey. That video survey details has to be announced, but the video was leaked and Hindus were claiming that there is Shivalinga in the mosque, whereas Islamic groups claiming that as a fountain head, water fountain. So Hindus, they appealed that they should be allowed to visit that place and they should be allowed to worship. So Islamic groups, they went to High Court, Allahabad High Court they went. Allahabad High Court dismissed their petition, so they went to Supreme Court. Supreme Court allowed the Islamic people to do pray in the Gyanvapi Masjid case, and Supreme Court also given direction that the places which are claimed as Hindu significance, those places must be protected. Those places must be protected, and the rest of the details, rest of the case, again Supreme Court forwarded back to, they reverted back to Varanasi District Court. Varanasi District Court will find out all the preliminary details, and if it gives final judgment, then we will examine. So now Supreme Court turned the case to Varanasi District Court. Now the Varanasi District Court, what it given the orders? Varanasi District Court given the orders that the Archaeological Survey of India, ASI will do the survey in Gyanvapi Masjid. Gyanvapi Masjid. In Gyanvapi Masjid, ASI, Archaeological Survey of India will do the survey, and based on the survey, by considering that also, we will give the judgment. That is the recent update. Recent update is Varanasi District Court given orders, okay, that Archaeological Survey of India will do the survey in Gyanvapi Masjid. So this is the overview you have to understand. And this Place of Worship Act, this act was brought during the time of P.V. Narasimha Rao as Prime Minister. At that time, this Babri Masjid demolition was happened. Okay, regarding the religious institution, regarding the freedom to maintain the religious institution, Article 26 talks about the institutions, whereas regarding the individual freedom to religion, Article 25 speaks about the freedom of religion with respect to individual. So this is the overview regarding the Babri Masjid case. Okay, first context. Varanasi Court given direction regarding the scientific survey of Gyanvapi by the Archaeological Survey of India. Like I said earlier, here you are talking about one is Varanasi District Court, place is Gyanvapi Masjid, and organization involved is Archaeological Survey of India. Regarding Archaeological Survey of India, we will discuss in the end of the video. Next, background, Gyanvapi Masjid case. This entire dispute started in 1991. In 1991, group of people, they requested for the prayer in Gyanvapi Masjid. In 2019, Allahabad High Court given stay on archaeological survey that was requested by the petitioners. These Hindu petitioners, they requested for the archaeological survey stay, this survey. This was stayed by Allahabad High Court. Now, Varanasi District Court ordered, because now Supreme Court said that Varanasi District Court will deal with the preliminary investigation of the case. Okay, they order now. Then 2022, 5 women, they requested that they would like to do regular prayer in this masjid, Gyanvapi Masjid, and to offer their prayer to the Sringar, Gauri and other idols within the Gyanvapi mosque. They requested for the prayer. Actually, from there onwards, the issue again came into limelight, 2022. Then the court ordered the videograph survey, and the videography survey, that videos were leaked and Hindus were claiming that there is one Shivalinga, and Muslims quoting that it was a fountain head. Already I told you. And Muslims also quoting that, Muslim groups also quoting that this comes under the Place of Worship Act. So this dispute cannot be invoked again. Okay, the matter goes to Supreme Court. Matter this reverted back to Varanasi District Court. Varanasi District Court, and it given stay on the Allahabad High Court judgment. Allahabad High Court judgment. This case transferred to now again Varanasi District Court. I explained that this Varanasi District Court dismissed the challenge made by the this Masjid Committee. Masjid Committee is claiming that it will come under the Place of Worship Act and it cannot be, this dispute cannot be started again, so Hindus should not be allowed. But according to the Code of Civil Procedure, CPC, you know that students, there are civil laws and criminal laws in India. Criminal laws are codified into IPC and criminal laws are implemented through CRPC, whereas civil laws are coded through CPC, Civil Procedure Codes. According to Civil Procedure Code, obviously, when you are claiming something, okay, when you file a case, you are a plaintiff. When plaintiff is claiming something, that means here Hindu groups, they have to prove that they belong to and Hindu religion, and there are certain Hindu religious idols are there. That is the reason they requested the archaeological survey, and now that archaeological survey was granted. Okay, and this temple, the Hindu groups are claiming that this temple architecture used in the Gyanvapi, it belonged to Kashi Vishwanath temple. Okay, regarding the Place of Worship Act 1991, the cutoff date 15th August 1947. So by time of 15th August 1947, whichever the religious institution, the nature of the religious institution will not be changed. Okay, the status quo will be maintained. Exception given to ancient and historical monuments, archaeological sites, and by that time already Babri Masjid case in court matters. That is the reason Babri Masjid got exempted from this Place of Worship Act 1991. Why was this act was introduced? This act was introduced to prevent further disputes like Babri Masjid, because these kind of claims are going to be unlimited. Always remember students, according to law says that state has to prevent continuous litigation. State has to prevent continuous litigation. Okay, disputes must be prevented by the state. That we have to understand. Challenges to the pleas of this act. Some people are objecting this act is not constitutionally valid. Why? First one, according to this act, we are taking out the judicial review. We are saying that after 15th August 1947, the nature of the religious institution cannot be questioned. That means petitioners are depriving of judicial review. But judicial review is one of the feature of the basic structure. Second one, so why the 15th August 1947? Why not the 26th January 1950? There are certain conditions are there. Why such things are exempted? And it is restricting the fundamental rights with respect to Article 25 and 26. And it is not in the spirit of the secularism. These are some of the challenges claiming against the act. Why it is against the secularism? Because secularism means all the religions must be given equal importance, and this law is violating that, and this law is giving exemption like archaeological structure and all these things. So some petitioners are challenging this act. Now, Archaeological Survey of India. Now the Varanasi District Court ordered the Archaeological Survey of India's survey. Now let us see some information regarding the ASI. ASI, it comes under the Ministry of Culture. For the first time, it was conceptualized in 1861 by Alexander Cunningham, and it involves in the maintenance of the archaeological structure. Of course, it also enforces one more act, that is the Ancient Monuments and Archaeological Sites and Remains Act 1958, and it also regulates the Antiques and Art Treasure Act 1972. These two statutes also implemented by the Archaeological Survey of India students. Now, last video question. Consider the following pairs, regions and their countries. Catalonia, Spain, this right, and Crimea belongs to the Ukraine, so it is saying Hungary. Mindanao, it related to Philippines, and Oromia, it is not related to Nigeria. So answer is 1 and 3, C. Okay. Now we'll see today's question. Let's see students. today's question. Consider the following statement. The Constitution of India defines its basic structure. Constitution of India defines its basic structure in terms of federalism, secularism and all these things. Second one, the Constitution of India provides for judicial review to safeguard citizens' liberties and preserve the ideals on which the Constitution is based. Which of the following statement is right? Okay, read carefully and answer it. Mains question. Religious interpretation of history is posing threat to the present secular nature of the state. Critically analyze. That means we should look history in terms of neutral way, but when you are attributing religion to the history, that is affecting the present secular feature of the India. And critically examine this statement. As we reach to the end of this video, we do a quick revision. So here we discussed about what is this Gyanvapi Masjid dispute is about, and what is the viewpoint taken by the Hindus and Muslim groups. And we also discussed about one legislation, that is the Place of Worship Act 1991, exemptions from that act. And we also discussed about one institution, that is Archaeological Survey of India, and what kind of laws are implemented by the Archaeological Survey of India also we discussed. So this is the detailed analysis regarding the Gyanvapi Masjid case.